Senate is returned to order. Mr. Secretary, will you read a message from the House?
The following message was received from the House through Mr. Riley, the clerk thereof. Mr. President, the House has passed by the requisite constitutional majority the following bill of the House, HB 974, by Representatives Burns of the 159th and others. A bill to be entitled an act to make and provide appropriations for the state fiscal year beginning July 1st, 2026 and ending June 30th, 2027, to make and provide such appropriations for the operation of the state government and its departments, boards, bureaus, commissions, institutions, and other agencies for the university system, common schools, counties, municipalities, and political subdivisions, for all other governmental activities, projects, and undertakings authorized by law, and for all leases, contracts, agreements, and grants authorized by law, to provide for the control and administration of funds, to provide an effective date, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Chair recognizes the Senator from the 14th.
Parliamentary inquiry.
State your inquiry.
Mr. President, I feel like through stages we have learned the majority's batting order for the chair. I'm aware of the Lieutenant Governor. I'm aware of the Pro Tem, Mr. Leader. I'm also aware of the Senator from the 1st. What happens if the Senator from the 1st is not available, and how far down the list is the chair willing to reveal the list goes?
Well, if you're playing on a world championship team, that means all 9 of the individuals in the batting order better be able to pick up the bat and take us across the finish line.
All right.
So all the way down, that's pretty far.
I'll be waiting with bated breath for district numbers, and I'm sure the mysteries will reveal themselves.
I mean, even if we have
to
call on the Senator from the 6th to come up here and save us, we will do that.
I understand, and just so the chair knows, I'm always willing to offer my services.
I appreciate your services. You're a good Georgian, Senator. The chair will assign House Bill 974 to appropriations. All right, we're going to come back to order. The Secretary will read House Resolution 1008.
House Resolution number 1008 by Representative Smith of the 70th and others. To ratify amendments, a resolution to ratify amendments to a certain comprehensive statewide water management plan, to provide for force and effect, to provide for construction, to provide an effective date, to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the House on Information and Audits, the Committee of the Senate on Natural Resources and the Environment recommends that this resolution do pass. Respectfully submitted, Senator Anderson of the 24th Chairman. Mr. President, that completes the order.
I recognize the Senator from the 49th to speak to House Resolution 1008.
Thank you, Mr. President. Good afternoon, colleagues. I present to you House Resolution 1008. This resolution is the product of work that occurred out of session this past year to reconvene the State Water Council and make minor tweaks to our regional water councils. I want to thank the chairman from the 24th and the chairman from the 11th for serving on the State Water Council this off session and working through these changes with those other members. The reason you don't see those changes in the legislation is that our role and the House's role to either approve or reject the changes proposed by the State Water Council to the state water plan. This process was created to ensure our state's water plan would be crafted with local input, guided by data from EPD and approved by the General Assembly. This ensures water planning is being done by those directly using the resource and informed by sound science from EPD. The House passed this resolution out of its chamber unanimously. The changes you don't see on the paper, though, are very simple. All 10 regional water councils will have their overall membership reduced from 25 to 15, eliminate the option for alternate members, extend members' terms from 3 to 6 years, and ensure representation from the municipal, industrial, agricultural, and energy sectors on the council. These changes were made to help reinvigorate our regional water councils and improve their ability to serve their communities. In many other councils across the state, seats are going unfilled, councils are not meeting, and there is not enough interest to fill the current high volume of seats. This leaves the councils unable to complete their responsibilities and provide input to EPD and policymakers. I kindly ask for your support of H.R. 1008. Yield for question.
Recognize the senator from the 14th.
Thank you, Mr. President. Senator Yield.
Yes, sir.
Senator, how many votes do you need to pass this today?
All of them.
Well, I don't think they're here yet. So. This is a simple majority vote?
Yes.
Okay, great. Gotta love that. Thank you.
Yield the well.
Senators yielded the well. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none and the question is ordered. Is there objection to agreeing the report of the committee which is favorable to the adoption of the resolution? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none and the question is ordered. Question is on the adoption of the resolution. All those in favor of the resolution will vote yea, opposed nay. The secretary will unlock the machine. On the adoption of the resolution, the yeas are 43 and the nays are 0. This resolution, having received the requisite constitutional majority, is therefore adopted. Senator from 41st, what purpose do you rise?
Thank you, Mr. President. I ask for unanimous consent to excuse the senator from the 22nd.
Without objection, the senator from the 22nd is excused. Secretary will read the caption to House Bill 945.
House Bill number 945 by Representatives Williamson of the 112th and others. A bill to be entitled an act to amend Title VII of the Official Code of Georgia Annotated relating to banking and finance so as to provide for holds on accounts of eligible adults for suspected financial exploitation. to provide for procedures for placing and lifting such holds, to no longer require independent credit reports to be obtained from a consumer reporting agency, as defined in the Federal Fair Credit Reporting Act, to provide for procedures for cease and desist orders for unregistered persons providing litigation finance, to provide for judicial hearings to review department decisions regarding litigation finance, to provide for registrant disclosures, to provide for definitions, to make conforming changes, to provide for construction, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Banking and Financial Institutions recommends that this bill do pass. Respectfully submitted, Senator Summers of the 13th, Chairman. Mr. President, that completes the order.
Recognize the senator from the 3rd to present the bill.
Thank you, Mr. President. Colleagues, I have House Bill 945. It is the annual cleanup bill for the Department of Banking and Finance. It's 40 pages. A good bit of it is changes to rules and regulations. However, there are 3 areas that I would like to highlight for you. Transaction holds, virtual currency kiosk, and litigation financing. And this is a little complicated, so I'm probably going to read some of this, if you'll bear with me. Financial exploitation is an endemic problem as it has increased significantly in the last few years across the country, including Georgia. Financial exploitation results in the target individual, who is often a disabled or elderly adult, going to their financial institution to withdraw significant amounts of money to send to the scammer. Under current law, banks and credit unions are limited in the actions it can take to prevent their customers from withdrawing these funds, even if the financial institution strongly believes that the withdrawal is the result of financial exploitation. Approximately half the states have enacted what the industry refers to as transaction hold laws. This bill proposes to do the same thing to provide the same protection for Georgia consumers. It's worth emphasizing that this is entirely discretional of financial institutions and applies to individual transactions as opposed to the entire account. This proposal will allow financial institutions to place a hold of up to 15 days on an individual transaction that the financial institution reasonably believes may involve, facilitate, result in, or contribute to financial exploitation if the customer is an eligible adult. Eligible adults include disabled adults, which is defined in code, or elderly adults, those people over 65. In addition to placing a hold on the transaction, the financial institution may reach out to what this bill refers to as a trusted contact. That would be an adult designated by the account holder, and notify this trusted contact of the suspected financial exploitation. Once a transaction hold has been placed, the financial institution must initiate an investigation. If the results of the investigation do not indicate financial exploitation, the institution may consummate the transaction at the conclusion of the investigation. However, if the investigation is not concluded but continues to look like financial exploitation, the financial institution may extend the transaction hold for an additional 15 days. There's an opt-in provision in this bill. Prior to implementing any transaction holds, the financial institution must have policies and procedures in place and must have trained its employees. If the financial institution acts in good faith with reasonable care, the financial institution will not be liable for placing the hold. The second item is virtual currency kiosk, also known as Bitcoin ATMs, have become a significant industry over the last several years and are currently licensed with the department as money transmitters. However, because of the nature of transactions at these kiosks, this is where individuals are putting cash into the kiosk and it's immediately exchanged for a virtual currency and placed in a so-called internet wallet. These kiosks are often used for fraud, for scams, and other illicit activity. A typical scam may involve the scammer calling the target and presenting a scenario like an outstanding bench warrant or a relative in jail that the scammer claims can only be resolved by the target depositing large amounts of cash into a kiosk. Once the cash is deposited, there's often no recourse for the target to recover the funds. Nationwide, the FBI has noted a 99% increase in the number of complaints regarding virtual currency kiosks from 2023 to 2024, with a loss of over $240 million nationwide. In addition, virtual currency kiosks have been linked to other illicit activity, including money laundering, drug trafficking, and human trafficking. Approximately 16 states have enacted legislation to place heightened requirements on virtual currency kiosks, and this bill proposes similar language that will protect Georgia consumers and discourage illicit actors. All right, some of the important requirements are: 1, disclosures that, among other information, will alert consumers that 1, the transaction is irreversible. 2, virtual currency transactions are often used to defraud consumers. And 3, virtual currency is volatile and unpredictable, which may result in partial or total loss of certain virtual currencies. This bill limits the fee charged by virtual currency operators to 18% of the total transaction amount. Currently, some operators charge upwards of 30%. Bill limits the aggregate daily transaction amount to $2,500 for new customers. New customers being defined as the first 72 hours after a customer opens the account, and $10,000 for existing customers. As far as refunds go for new customers, the total amount of the transaction can be refunded if they were fraudulently induced to enter into the transaction and reported such transaction to law enforcement and the kiosk operator within 5 days. And then for all customers, the fees can be refunded, fees related to the transaction if they were fraudulently induced to enter into the transaction. An additional compliance mechanism including receipts with certain information regarding live customer support, the use of blockchain analytics to enhance the ability of the virtual currency kiosk operator and the department to identify fraudulent transactions. And then third and finally, regarding litigation financing, the litigation financing law passed in 2025 as part of our tort reform effort went into effect on January 1, 2026. Broadly speaking, this law protects consumers from abusive behavior by creating a disclosure regime for litigation financiers, eliminates foreign influence in civil cases by restricting foreign ownership of litigation financing, and requires litigation financiers to register with the Department of Banking and Finance. And 4, it makes the involvement of a litigation financier discoverable in civil cases. This bill has some revisions to the existing laws that will close some of the apparent gaps and more closely align with the department's regulation of other non-depository financial institutions. These changes will help ensure that the vision of the law is achieved, and these changes include: they propose to change the definition of financial institution to include bank holding companies and credit unions, which is the alignment with the typical understanding of a financial institution under Title VII. The bill proposes to require annual registration as opposed to currently a one-time registration. This ensures that companies remain eligible for registration that have not made any changes to their ownership structure or otherwise that would make them ineligible. This is critically important as the department does not have authority to investigate or examine litigation financiers that would otherwise not have access to this information. Further, this is in alignment with other regulated industries. The bill would allow the department to access conviction histories for owners, officers, and directors of litigation finance. This will allow the department to actually enforce the ban on individuals with a felony conviction within the last 10 years, that is, in the current law. And this bill would allow the department to issue cease and desist orders to entities or individuals who are operating without a license. Currently, the department's only remedy is to refer such entities or individuals for criminal prosecution. This will enable the department to enforce this registration requirement without involving agencies that are busy prosecuting serious felonies. And I would mention that the Department of Banking and Finance consulted with affected parties here. This legislation was shared with the Georgia Bankers Association, Community Bankers Association, Georgia Credit Union affiliates, the Mortgage Bankers Association, the Georgia Financial Services Association, the Georgia Installment Lenders Association, the Alliance for Responsible Consumer Legal Funding. And there has been no industry opposition to this bill. Mr. President, with that, I'll pause for questions.
No questions, Senator, but there is a
Thank God,
amendment.
Mr. President.
There's an amendment that's been offered. Yeah. All right, we've got an amendment that's been offered. Secretary will read the amendment.
Mr. President, Senator Tillery of the 19th and others offered the following Amendment 1 to amend HB 945 by inserting 10 after 7 on line 1, by inserting commerce and trade after finance on line 2, by inserting to protect the exercise of constitutional rights, to prohibit discrimination in the provision of essential services, to provide for public and private enforcement before to provide on line 24, by inserting after line 975 the following: Article 15 of Chapter 1 of Title 10 of the Official Code of Georgia Annotated relating to deceptive or unfair practices is amended by adding a new part and for other purposes. Mr. President, that completes the order.
Senator from the 19th, would you like to speak to your amendment?
Thank you, Mr. President. Senators, my amendment goes back and carries us back to last year, a debate we had. If you remember, we've seen people in our state who've had their bank accounts or other essential services closed because they did things that were otherwise protected by the Constitution. They owned guns. They manufactured guns. They went to speeches. And for some reason, because they did those things that were otherwise constitutionally protected, they saw their debit cards or their bank accounts closed. That's wrong. That's not something that we should support. So I authored a bill last year. You know, we debated it thoroughly. It lost on the Senate floor. And after it lost on the Senate floor, the very next day, the President of the United States, again, it lost with the arguments being made that debanking very rarely happens and that it's just some scheme for lawyers. The very next day, President Trump filed suit in Florida alleging 300 counts of debanking against Capital One Bank. 300 doesn't sound very small to me. And if we're having Georgia companies have their bank accounts closed only because they make firearms like we saw with Daniel Defense down in Savannah, or we're having Georgians in Southwest Georgia who were traveling to a political speech and got outside the state and all of a sudden their bank accounts got closed, that's wrong. It's wrong for conservatives and it's wrong for liberals. We just saw Jamie Morgan, one of the biggest banks in the country, admit that they took steps to intentionally debank political speech, mainly aimed at conservatives. This is no longer theoretical. It's as real as it gets. And we are the body that get to make the laws of our state and how we will respond when people's Second Amendment, First Amendment, any other amendment rights are silenced by corporations and boardrooms. That's all this is. If you think that someone's right to bear arms shouldn't lead to them seeing their bank accounts terminated, their power bills terminated, their water bills terminated, any essential service, then your vote on this amendment should be yes. But if you think it's okay to turn off someone's bank accounts, their water, their power, things that my friends in the minority party fight against when landlords do it, if you think it's okay to do that just because somebody owns a firearm or makes a firearm or engages in political speech, then you should vote no. Thank you, Mr. President. I'd urge your favorable support of Amendment 1.
You have a question or two, Senator, if you're willing to take them. Chair recognizes the senator from the 29th.
Thank you, Mr. President. Does the senator yield from one gun owner to another?
Sure.
Senator, could you tell me how many cases of debanking we currently have here in the state of Georgia that you are aware of?
You have had at least 3. But my comment back to you as someone who I know supports due process is when someone's due process rights get eliminated, how many have to be eliminated before we think it's enough? I think if it's 1, that's too many. But thank you.
Thank you.
I recognize the senator from the 26th.
Thank you, Mr. President. Senator Yield,
Yes, sir.
on page 2 of your amendment, lines 34 through 36.
Yes, sir.
That is a what you call a DEI exclusion?
No, sir. What it says is that you can't create a social credit score. So go to line 28. What we saw is in communist China, they created a social credit score and ranked people for how they would have housing, how they would have banking, how they could pick their jobs based on certain things they did of whether or not they engaged in speech that was protected or supported rather by the government. And one of those things was whether or not they would engage in diversity, gender audits, and things like that. So when we were defining what a social credit score means, we went back and grabbed what the communist Chinese definition was and put it in there and said that's not something that you want in Georgia.
Senator from the 16th has a question.
Senator Yield for a
Yes,
question.
sir.
I think this is realizing, and I think you would say this, that money is freedom. And when an organization can cut your money off, they're really attacking your freedom. And my question is penalties on this. What are the penalties that can be assessed? Because when a bank shuts down, I have a friend who was a pro-life position, and a bank in California shut him down completely, and he didn't understand why, and it took him days to get all of his accounts done. But there should be some penalty for that, and there needs to be a quick remedy for that, because when your accounts are shut down, How does this help us from that standpoint? Penalties, and what are the time frames to resolve the issue?
Yes, thank you for those questions. They're really good, and thank you for your kind comments to lead in. What we actually saw, and we had testimony in committee when we had this bill even last year, the gun manufacturer in Sylvania, Daniel Defense, said that it cost him $1 million each time his accounts were closed, and he was debanked twice. What did he do? He made firearms. That was it. The penalty in this is your actual damages, what it cost you to reopen accounts and do all those things, or we set a nominal value, and it's a big dollar, at $50,000 per an occurrence, whichever's greater. So if yours go higher, then, hey, you can recover what you had. If you can't, then we set the penalty at $50,000. Why? We're not trying to put anybody out of business, but we are trying to say this is darn important. And to limit someone's constitutional rights by limiting and eliminating their essential services, that's just wrong. And everyone should be able to agree on that, regardless of if you're conservative or liberal.
Yield for a second question.
Yes, sir.
Here's the other part. Is there a way in which this bill might address a notification prior to shutdown that is mandatory, that they give you some type of notice rather than just shutting down your accounts? Is there any way, and does this address that issue of notification of being shut down?
So we tried to work through that process last year, and what some of the folks told us is, well, let me tell you, the power company said there was no problem. The water company said there was no problem. The internet company said there was no problem. The only company that said there was a problem were the banks. So if this has been named the debanking amendment, it's because the only folks who had a problem with it were the banks. Georgia Power was fine. Everybody else was fine too.
But there is no notification. So this could be happen tomorrow. Since you and I brought this up, the bank could sit down and shut us down.
The comments that they made is that there's federal rules that prohibit them from telling you, because if they did, they might be engaging in some type of fraudulent activity. We tried to exclude all of that activity. We said, look, it's just about things that are otherwise protected by the Constitution. Literally tried to limit it to the first 10 amendments. When we
Thank
did
you,
the first
sir.
time.
Thank you.
Senator from the 46.
Thank you, Mr. President. Will Senator yield?
Yes, sir.
Senator, I recall this bill from last year, and although I applaud the intent behind it, where I have a problem is there on the bottom of page 3, where you give the private cause of action. You're creating a new tort with a minimum automatic damages of $50,000. That is so out of whack with the remainder of the Fair Business Practices Act, which you've tucked this under. Why such drastic recovery, $50,000 as a minimum plus attorney's fees, rather than just let it follow under the provisions of the Fair Business Practices Act?
The Fair Business Practices Act, I believe, goes up to 100. So we actually cut it in half at 50. Everything else, including attorney's fees, are allowed under the Fair Business Practice Act. So this is not being kinder to attorneys. If anything, it's saying, hey, we realize that this is going to be a heartburn issue for some people. It shouldn't be. The only time this can be exercised is if somebody's ending someone's Second Amendment rights or their First Amendment rights. So we cut it in half. Everything else that you see under that is allowed already under the Fair Business Practices Act.
I don't remember it that way, but I'll check that. Thank you.
Mr. President, if there are no further questions, thank you.
We do have further questions,
Happy
Senator.
to continue.
Chair recognizes the senator from the 55th.
Thank you to the gentleman in the well. Will you yield?
I'd be happy to yield to this debate about freedom.
Yes, sir. You, in your talk, you spoke on page 2 of paragraph E about munitions and firearms, but I don't understand why you have A through D, and you mentioned something about getting this from China, and I don't think a lot of this is applicable to the homogeneity of China. Can you tell us a little why you have A through D?
Sure.
Thank you.
We had a question last year about, could someone define social credit score? That social credit score was some nebulous concept that didn't exist. Turns out social credit scores existed for 30 to 50 years in communist China. And when we look to see what is the Chinese government taking and putting a social credit score on people for, it was things of whether or not they fell within what the government believed was right. And those things are A through E. That's how we got to that definition.
Recognize the senator from the 10th. for a question.
Thank you, Mr. President. Senator Yield?
Yes, sir.
Senator, I hate to keep beating the same drum, but I'm trying to really wrap my mind around this social credit score.
Yeah.
I'm familiar with a traditional credit score from one of our credit agencies. How would this kind of information on a social credit score be cataloged?
Yeah.
And who would do it? Can you explain?
So yes, sir, happy to, and thank you for that question. This has nothing to do with someone's credit score as to whether or not they are worthy enough to get a loan or not. That's not at all. What we've seen, it started in communist China, in socialism areas as well, where they took and ranked people. And I've said this 3 times, so either I'm not speaking it well or maybe folks aren't hearing it well. But here's what happened. Those governments took and ranked folks on whether or not their speech and their actions were in line with what the government thought was appropriate. That's literally what communist China does. We know that. You've got to be a member of their political party to run for office. So that's the definition we put in here is, hey, what was the government looking at in places like China to see if they agreed with the Chinese Communist Party's beliefs? And if you did, then obviously you received favor. That is not a reason why someone should see an essential service or a bank account eliminated here.
Senator Yield?
Happy to.
Senator, I'm trying to understand the relevance for the United States, not communist China.
Yeah.
I'm assuming this is a new kind of social credit score for the United States. And I don't believe that the form of government we have here even compares to a communist government over
Senator,
in
you're
Asia.
wrong. You literally had these social credit scores being used by our banks, and they admitted it. They admitted it in testimony that they did this. So we're just in a difference of belief of whether or not we think that big banks and big companies ought to be able to deny essential services to Georgians. I don't think they should. That's all the bill does.
Senator Further Yield?
Sure.
Senator, none of you said that banks are using it. How did the banks quantify the use of this nebulous number, if you will, or comparison?
Yeah, well, I think for that instance, I'd have to accept your premise that we should be using it at all. So what they were saying is that someone has if they engage in certain activities, they own firearms, they engage in speech, whatever it is that the bank or the company did not like, that they should be able to disassociate with them. I think freedom of association, also protected by our First Amendment, is very, very important. But when it butts up against the Second Amendment or the other amendment or the other rights that are guaranteed in the First Amendment, I think those rights, speech, the right to bear arms, etc., should trump the freedom of association.
Senator Further Yield?
Yes.
Senator, you just said a word, if. I'd like to explore that a little bit more. Can you tell me how a potential bank or lender would know if I owned any of those things, if I did any of those things, if I had any of those characteristics?
Well, Senator, the way we know that that is true is because it happened. You had a large gun manufacturer in our state closed. You had folks traveling to go be involved in speech, have their debit cards cut off. It isn't a question of if. You are literally joining the arguments from last year to say that this is a question of if it happens. It's already been proven it did. One of the top bankers in the country, Jamie Dimon at J.P. Morgan, said it happened. He admitted they did it. So why are we debating this debate of whether or not it happened? That's the same debate from last year, has already been debunked. The question now is whether or not we're going to do something about it. And the only people that get to decide that are the 56 souls that sit in this room.
Senator, if you further yield?
If
Senator,
there's actually a question, yes, sir, I will.
I think everything that I ask has always been a question. But I would like to know, how is it that a potential borrower would be able to find out what their social credit score would be, and how a particular lender would quantify it if they went to a particular lender for that kind of a resource to borrow
Senator,
funds?
you're thinking this has to do with when you go to borrow money. That's not how these people got cut off. They had established business relationships. They were already engaging in business with these companies. In fact, this amendment only says that there are penalties in place that the senator from the 46th talked about if you already had an established business relationship. This isn't whether or not they're going to apply for a loan at the first time. These folks have been banking with these companies for years. They've had essential services with these companies for decades, and then they're getting cut off. And the only thing they did different? Well, now what they're doing is not in the status quo of the liberal media's woke, progressive agenda. And that's the only thing that they've done differently.
Senator, yes, and I understand that there are certain criteria that lenders are going to look at. I'm not implying that a lender is going to use this social credit score. What I'm implying is, how would I, as a potential borrower, know what my
they're doing?
credit score would be?
I think you raise
in any kind of situation.
I think you raise a great point. Because if they're holding this internally, we did not know that these things were happening until literally the public started talking about them, and then the corporations started talking about them. We would have not known that was happening. It was assumed it was happening, right? And now you see that it is because the corporations have come out and admitted that it was. How would you, as senator from the 10th, known that you had a social credit score? You wouldn't. Your bank accounts would have been cut off one day. And what would have they been cut off for? Well, was it because you were the senator from the 10th? Was it because you voted for something that was out of line with the mainstream agenda? Was it because you bought a firearm at a Georgia firearm manufacturer 2 weeks before? I don't know. But the thought that that was actually happening, and now it's been proven to have happened, that's where we have to stand up and say, we knew it happened, or we didn't know it happened then, we're protected from that. But now that we know that folks lost their Second Amendment rights, they lost their rights to own businesses simply because, and they were turned off on their utility services or their essential services because of it, that's wrong. And we're the only people in this state that can fix that.
Thank you, Senator.
Thank you. Mr. President, they lit me up to green again, but I'm sure you want me to yield the well.
Senator yields the well. Senator from the 33rd, 41st, what purpose do you rise?
Thank you, Mr. President. I ask for your ruling on the germaneness of this amendment. I would like for your ruling on that.
All right, stand by. I assume you're talking about Amendment 1, is that right? After reviewing the amendment is related to banking. It's an amendment to a agency banking cleanup bill, which normally we try not to amend, but do rule the amendment is germane. All right, we got at least two more amendments. Amendment 1A, the Secretary will read the amendment.
Mr. President, Senator McCorn of the 14th offers the following Amendment 1A to amend Amendment 1 of House Bill 945 by replacing $2 billion with $10 trillion on line 22. Senator Howard of the 35th offers the following Amendment 1B to amend Amendment 1 of House Bill 945 by adding between lines 49 and 50, quote, a person's failure or refusal to express support for an administration, whether statewide or federal, end quote. Senator Burns of the 23rd and others offered the following Amendment 1C to amend House Bill 945 by striking the 2 on line 19 and line 22 and replacing with 5. Mr. President, that completes the order.
Chair recognizes the senator from the 6th. What purpose do you rise?
Mr. President, I make a motion to resolve debate.
Motion from the senator of 6 is to resolve debate. All those in favor of the motion will vote yea. Those opposed, nay. The secretary will unlock the machine. On the motion to resolve debate, the yeas are 43 and the nays are 3. Per Senate rule, once debate is resolved, I'll allow 3 senators to speak at the chair's choosing, and then we will let the author of the bill, Senator from the 3rd, close debate. Senator from 6, what's your purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that resolving debate also closes out no more amendments?
That is correct. Chairman of the rules knows his rules. Stand by. All right, the chair is going to allow so the Amendment 1, the author of Amendment 1 has already spoken to his amendment and had a lot of questions and good dialogue there. So I feel like he's gotten his opportunity. I'm going to allow the senator from the 14th. He has Amendment 1A. I'm going to allow him to speak. And then I'm going to allow the senator from the 23rd. Just stand by those, Senator. Senator from the 23rd will speak. He's got an amendment. And then I'm going to let the chair of the Senate Banking Committee speak, the senator from the 13th. And then I'm going to allow the senator from the 3rd to close debate. So, senator from the 14th.
Thank you, Mr. President. I urge your favorable consideration of Amendment 1A.
All right. Senator from the 23rd, would you like to speak to your amendment?
Thank you, Mr. President. I'll be brief. Folks, I agree philosophically with the senator from the 19th bill, but I believe that $2 billion is too low. I'd like to ask and recommend that we move that to $5 billion. I'd appreciate your support for amendment number 1C. Thank you. You good? Thank you.
All right. Senator from the 13th, chairman of Senate Banking Committee.
Thank you, Mr. President. Folks, we were here last year. We debated this last year for quite some time. If you remember, the original debanking part of the bill went to judiciary instead of coming to banking department. And it was set up for the fact that it had probably, and I'm just guessing it, I can't remember the numbers, 46 times the word banking was listed in the bill that did not come to the banking committee. And here's what we got. I can't argue a lawyer, okay, because I'm not a lawyer. I can't speak the language that lawyers speak and whatever. But I know when I'm being had, when you try to put something in the system that shouldn't be there. The senator from the 3rd and I, my vice chairman on the banking committee, we sat there and we debated and we worked through the cleanup bill that was signed off by Bo Fears, who is the commissioner, the one the governor appointed over the banking in Georgia. And Bo Fears, who I think most of you all know in this room, in my opinion, is basically above reproach when it comes to this kind of stuff. And he's truly one of the finest individuals you'll ever deal with when it comes to getting the truth and hard answers done. And Bo Fears will tell you up front, this was not what was on the banking bill. This was not the cleanup bill. This bill right here has now changed. And in my opinion, what this bill has become is a lawyer bill. So we're going right back to tort reform again. So the question remains, do we put it back in where you can start suing again? Because we just passed tort reform. So what we should do is just recall tort reform from last year and just vote that out again and start over again. Because that's what we're doing. We're fixing it where every bank can get sued. And we're using the word gun to scare conservatives to say, well, there's gun manufacturers, you're going to get sued, so we got to protect gun manufacturers. This is not what this is about, folks. This is not what this is about. This is about what debanking truly means, and I doubt very seriously anybody in this room except a lawyer could tell you what that word truly means when it comes to debanking. But the reality of it is we're fixing a bill for lawsuits. And I don't think it's right. And I want you to vote down the senator from the 19th Amendment and go back to the original bill that the senator from the 3rd just presented in its clean form that was brought over from the House, who actually went through and worked this bill through. Representative Williamson brought this bill over, Bruce Williams brought this bill over, went through it with us, not line by line, but at least 35 or 40 minutes worth, going through this bill. We know what's in this bill is a cleanup bill. Now, why a cleanup bill has to be 40 pages, I ain't never figured that out, okay? But it's a cleanup bill, and it has been vetted thoroughly. And to add this to it simply puts us in a position we don't need to be in. We're getting into other issues that may not be what this chamber is all about. So here's the deal, folks. We got to vote the amendment down. We got to vote for the bill. Pass this out here and get it across, let the governor sign it, and we get a clean debanking bill. Once again, I can't talk lawyer, but I know when lawyer is being added to the mix. And I understand what's going on here in regards to how we're going to do it. So here's another fact. If we want to carry a true debanking bill, then a true debanking bill needs to come back next year when we come back in session and we have a biennium. We can work through debanking bills and we'll know what truly is a debanking bill. So I'm asking you all to vote the amendment down. I actually love the Senators on the 14th Amendment of the $1 trillion. I mean, that's pretty good. That about protect everybody. That pretty much come close, protecting everybody in the trillion area. I mean, I don't know any trillionaires yet, but I'm working on it. We hope we meet one day. That's right. But the reality of it is vote it down, vote this bill clean, and let's move on, or we're going to be here all day playing with this stuff, and we don't need to be here. This is something we should not be dealing with. We tried it, it failed, and we shouldn't be doing it again. Mr. President, I yield the well.
Senators yielded the well. Oversight on my part, the senator from the 35th did not get to speak to his amendment. He can waive, or would you like to speak to your amendment? He waives. Thank you. All right. I'm going to allow the senator from the 3rd to close debate.
Thank you, Mr. President. Part of me wants to just refer to my good friend from the 13th, the chairman of the Banking Committee, and just tell you what he said. But I guess since I brought it, I ought to talk about it a little bit. Several things. First of all, is this the venue to discuss this issue? It could be. Obviously it is because we're talking about it, but is it the proper venue? My good friend from the 19th has had all year to bring this bill and to bring this issue back. He has not done it. He's tagged it on to a cleanup bill which our Department of Banking needs to be able to operate. We should be incredibly thankful that we have the Department of Banking that we have. We have a robust, healthy set of banks in Georgia. It's one of the reasons we're the number one state in which to do business, because we have a very healthy banking climate and we have good bankers. And we have excellent supervision. I can remember when we had banking issues in the Great Recession of 2008, and we lost a number of banks. I was very much involved in the banking business at the time, and I got to see our regulators. I got to see them up close. They did an awesome job, awesome job. They're one of the reasons that we came out of it as unfazed as we did. My friend from the 19th says that it's up to the 56 senators in this room to decide what we're going to do about this issue. Well, we've already decided it. He brought it last year, and 56 people in this room voted it down. And they voted it down, I can't remember the exact margin, but it was healthy. So I don't blame him for bringing it back today. But I just don't think that, I think that if my friend wants to bring it back, I go along with the senator from the 13th and would listen to it on its own. Second thing that I want to say is I'm not a lawyer either, but I was a banker. I was a banker after college for 48 years and 2 years before college. I worked my way through college. I worked part-time as a banker, so that's 50 years in the banking business. 50 years in the banking business. I never saw one instance of what my friend from the 19th is talking about. I never heard the word debanking until recently. Think for a minute about your friends in your communities that are bankers. You go to church with them. You see them at the deer stand and the quail field. You see them at the grocery store. You see them at your kids' baseball games. And I got a question for you, and you know them. You know the bankers in your community. One question: are they woke? I don't think so. Some of the most conservative people I've ever seen are my friends in the banking business. They are not the type of people to trample on your constitutional rights. They do manage risk. In a bank, the money that you put in the bank, I want you to think about this. Of every dollar that's in the bank, at the most, 8% of it, 8 cents on the dollar, belongs to the bank and the bank shareholders. The other 92 cents belongs to somebody else. It belongs to you. You bring it in, you deposit it in the bank. The FDIC steps in and says, we're going to insure your deposits up to $250,000. But to do that, you better have healthy risk policies. And they make sure that you do. They make sure that you don't lend money where you can't get it back. They make sure that you don't open accounts that will end up costing you money. In our banking system, we have the state regulating state chartered banks. Most of our banks have state charters. We have the comptroller of the currency regulating federal charters. We have the FDIC regulating anybody who has FDIC insurance. And then we have the Federal Reserve regulating bank holding companies. And, you know, in my experience, I don't know, the Fed with the very large, very extremely large banks, the Fed may have leaned on them a little bit to make sure they had DEI policies and maybe some other small social gerrymandering, or excuse me, social manipulation. But again, I don't think they ever said, don't do business with a certain type of person. Don't do business with somebody who's in this business or that business. I trust and believe in the bankers in the state of Georgia. I know many of them. I've done it myself for a long time. I do not see this problem. I see this issue as an issue or a problem or a solution in search of a problem. That's what I see. And I think this issue should, if it needs to be debated more, I mean, again, we debated it last year and we beat it. But if it needs to be debated more, so be it. Let's do it next year, and let's do it at a time. Let's don't hold our banking department hostage. So, in closing, I would ask that you consider all the amendments unfriendly. I would ask that you withhold your support. I would ask that you support your community bankers and your bank department. And I would ask you to vote for this bill without any amendments. Thank you. Mr. President, I yield the will.
All right, Senators yielded the will and closed debate. The order we're going to go in, we're going to first, it'll be 1A and then it'll be 1C because they both are the same line item, and then 1B and then Amendment 1. Any objection to Amendment 1A? There is objection. All those in favor of Amendment 1A will vote yea, opposed nay. The Secretary will unlock the machine. Senator Tillery, Senator from the 19th, what purpose do you rise?
Mr. President.
Yes, sir.
Parliamentary inquiry. Is it not true that as the author of Amendment 1, I'm against 1A, but I will be supporting 1C by the senator from the 23rd?
Appreciate you sharing that, Senator. On the adoption of Amendment 1A, the yeas are 17 and the nays are 31. The amendment has failed. Now, Amendment 1C. Is there any objection to Amendment 1C? Is there objection to Amendment 1C? Without objection, Amendment 1C is adopted. All right. On Amendment 1C, those in favor of Amendment 1C will vote yea. Those opposed, nay. Secretary will unlock the machine. Senator from the 23rd, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that a vote yea on Amendment 1C would protect community banks in Georgia?
Senator has passionate about this issue for sure. On the adoption of Amendment 1C by the Senator from the 23rd, the yeas are 21, the nays are 28, and the amendment has failed. Now we will go to Amendment 1B. Is there objection to the adoption of Amendment 1B? All right, I hear objection. All those in favor of Amendment 1B will vote yea. Those opposed, nay. The Secretary will unlock the machine. On the adoption of Amendment 1B by the Senator from the 35th, the yeas are 27 and the nays are 22. The amendment has failed. Amendment's adopted. Sorry. I apologize. Y'all really keep me on my toes up here, that's for sure. Now we'll move to Amendment 1 as amended by 1B. Is there objection to the adoption of Amendment 1 as amended by 1B? There is objection. Those in favor of Amendment 1 amended by 1B will vote yea. Those opposed, nay. The Secretary will unlock the machine. On the adoption of the amendment by the senator from the 19th, the yeas are 9 and the nays are 41. The amendment has failed. Now we'll go on to the original bill by the senator from the 3rd. So on House Bill 945, unamended, is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Question is on the passage of the bill. All those in favor of the bill vote yea. Opposed, nay. The secretary will unlock the machine. All right, only in the Georgia Senate, after all that. On the passage of the bill, the yeas are 50 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. All right, moving on. Secretary, read the caption to House Bill 244.
House Bill number 244 by Representatives Cannon of the 172nd and others. A bill to be entitled an act to amend Code Section 36-81-7 of the Official Code of Georgia annotated relating to audit of financial affairs and transactions, contents copied to state auditor and public inspection, so as to provide for local governments to request and receive in certain circumstances due date extensions relating to filing annual audits with the state auditor, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on State and Local Government Operations General recommends that this do pass by substitute. Respectfully submitted, Senator Dixon of the 45th Chairman. Mr. President, Senate Committee on State and Local Government Operations General offers the following substitute to HB 244. A bill to be entitled an act to amend Article 1 of Chapter 81 of Title 36 of the Official Code of Georgia annotated relating to local government budgets and audits, so as to update and revise provisions, content, and form of annual audits by local governments, to authorize regulatory basis of accounting framework for certain annual audits, to authorize the state auditor to prescribe necessary forms and information contained in certain components of such audits, to provide for exceptions, to provide that certain public officers and employees may be liable for the failure of their offices to assist counties in complying with audit requirements, to provide for the temporary withholding of compensation for certain officers for failing to assist counties in complying with audit requirements, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
I recognize the senator from the 11th to speak to House Bill 244.
Thank you, Mr. President. Members of the Senate, I bring before you HB 244. This is dealing with the auditing of our local governments. As you know, we have small governments across our state and we have large governments. Currently, a lot of our small rural communities are having to do real physical audits that are very time consuming and take a lot of resources. And so this bill is allowing some of them to come in compliance with the state. Currently, if you're not in compliance with your regular accounting of the state, with the State Department of Audits and Accounts, you cannot receive state funds. And so this will allow some of our smaller cities to do a lesser version of an audit that's the state auditor has described as a special reporting framework for our smaller local governments that have resources to do that. A lot of them don't with the current status that we have. So we're just allowing them to come into compliance, but then every 5th year require them to do a real deal audit, gap audit, I think, as they describe it. And that's what the bill does. Mr. President, I'd be glad to take any questions, and definitely appreciate Representative Cannon and our state auditor on helping our rural communities get access to these funds. I'd be glad to take any questions.
You have no questions, Senator.
Thank you. Appreciate your support.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 48 and the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Secretary, read the caption of Senate Resolution 771.
Senate Resolution number 771 by Senator Robertson of the 29th and others. A resolution creating the Senate Study Committee on Adoption and Permanency Affordability and for other purposes. Mr. President, the Senate Committee on Children and Families recommends that this resolution do pass. Respectfully submitted, Senator Kirkpatrick, Chairman. Mr. President, that completes the order.
Recognize the senator from the 29th to speak to Senate Resolution 771.
Thank you, Mr. President. Colleagues, on June 24th, 2022, the landscape changed throughout this country. Adoption became a viable option here in Georgia, a greater opportunity than ever before. What we need to do now is establish an adoption process here in Georgia that is affordable and transparent so that the children who want to be adopted or who their mother and father want to put them up for adoption have the opportunity to move into a loving family. And those who choose to adopt should understand the process much better. I'm hoping that this study committee will also address the affordability of adoption and the responsibility of adoption. And so I ask that everyone support this who want to give children in Georgia a safe and forever home so that they can grow and flourish in a state that we all love. And with that, Mr. President, I'll yield the well.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Is there objection to agreeing the report of the committee which is favorable to adoption of the resolution? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Questions on the adoption of the resolution. All those in favor of the resolution will vote yea. Opposed, nay. The secretary will unlock the machine. On the adoption of the resolution, the yeas are 50 and the nays are 0. This resolution, having received the requisite constitutional majority, is therefore adopted. Secretary, read the caption of House Bill 115.
House Bill number 115 by Representatives Petrie of the 166th and others. A bill to be entitled an act to amend Chapter 7 of Title 52 of the Official Code of Georgia annotated relating to registration, operation, and sale of watercraft so as to provide for certain notice upon registration of a vessel with the Department of Natural Resources, to provide for performance of unattended vessel checks, to authorize restitution to the Department of Natural Resources for the cost of removal, storage, and disposal of abandoned vessels, to provide for definitions, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Committee of the Senate on Natural Resources and the Environment recommends that this do pass. Respectfully submitted, Senator Anderson of the 24th Chairman. Mr. President, that completes the order.
Recognize the senator from the 1st to speak to House Bill 115.
Thank you, Mr. President. You know, under the Gold Dome, when we hear the number 159, we think of the counties here in the state of Georgia. But let me tell you what 159 means on the coast. The coast means there are 159 abandoned vessels on our coast. And when I say abandoned, I mean vessels that are just pushed off into the sunset, or they're sunk, they're pushed up into the marsh. As a matter of fact, on Skidaway River, which is right in the heart of Savannah, thank you, Mr. President, there was a vessel that was abandoned there from New Jersey. So yes, we have a problem here in the state of Georgia, but it's not all of our problem. We've been working on this particular bill for about 4 years now, and this bill has been perfected. It's in line with all the agencies and the law enforcement. What this does, this establishes the ability of DNR to board the vessel just to check out from a safety standpoint, label it abandoned. They search it in the computers and see if there is an owner, and the owner has about 30 days to remove the vessel. If not, then they have to pay for the removal once DNR removes it and makes it safe for the citizens. Let me tell you what an abandoned vessel does. So yes, we do take them out and sink them off the coast, but all of those vessels have been stripped clean. They are without chemicals. They are without the diesel fuel. They're without all the pollutants. Also, the abandoned vessel poses significant risk to the safety of those like my family goes out and skis in the Intracoastal Waterway, or fishes in the Intracoastal Waterway, or boats in the Intracoastal Waterway. So it's a safety and a politically friendly way to address these abandoned vessels along the coast. With that, Mr. President, I'll be happy to answer any questions. If not, I'll ask for your favorable consideration.
You do have a question or two. Recognize the senator from the 29th.
Does the senator yield?
Absolutely.
Senator, under your bill, would the USS Minnow have been declared an abandoned vessel?
Wow, the USS Minnow. You know, it may have, because it was up on the shore there, but it was probably along the shoreline.
Do you further yield?
Yes, absolutely.
Did the 7 occupants of that vessel not live nearby?
Well, they did live nearby, but, you know, I would probably defer to the gentleman from the 29th since he knows a lot more about law enforcement than I do.
Thank you, sir.
Thank you. I think with that question, I will yield the well.
Well, it was just a 7-hour tour, I think. I don't know what happened there, but 3-hour tour. It's just in my day. Does any other senator wish to speak for or against the measure? The chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Is there objection to agreeing the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. Senator from the 56th, what purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Is it not true that had there not been the courage from the Furious crew, the Minnow would have been lost?
Well, you are our public safety chairman. Thank you. Chair recognizes the senator from the 6th.
Parliamentary inquiry.
State your inquiry.
Is it not true that row is not near as funny as they think they are?
Senator definitely knows of which he speaks. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. I recognize the senator from the 8th for a motion.
Thank you, Mr. President. Pursuant to Senate Rule 7-1.10b, I give notice that on the next legislative day, I intend to move that the Senate consider House action on SB 59, Groundhog Day, Mr. President, but maybe next Thursday we'll get it.
Secretary will read the caption.
Senate Bill number 59 by Senators Watson of the 11th and others, a bill to be entitled an act to amend Code Section 48-5-7.4 of the Official Code of Georgia annotated, relating to preferential assessment for bona fide conservation use property and bona fide residential transitional property, so as to remove a limitation on leased property as to certain entities, to provide for related matters, to provide for an effective date and applicability, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Senator has given notice. Thank you, Senator. I recognize the senator from the 31st for a motion.
Mr. President, I move that the Senate stand adjourned pursuant to H.R. 998 till 10 a.m. Thursday, March 12th.
Secretary, read the announcements.
The Rules Committee will meet upon adjournment of the Senate in room 450 Cap. The Children and Families Committee will meet at 2:30 p.m. in room 450 Cap. The Retirement Committee will meet at 2:30 p.m. in room 310 CLOB. The Insurance and Labor Committee is canceled. The Education and Youth Committee will meet at 3:30 p.m. in room 307 CLOB. The Higher Education Committee will meet at 4:30 p.m. in 307 CLOB. And the Regulated Industries and Utilities Committee will meet in room 450 Cap at 5:30 p.m. Mr. President, that completes the order.
The majority leader has moved that the Senate stand adjourned until 10 a.m. on Thursday, March 12th. All those in favor of the motion will signify by saying aye. Aye. Those opposed, no. No. The ayes clearly have it, and the Senate is adjourned.